Assalamualaikum warahmatullahi wabarakatuh and a very good morning and welcome to our webinar collaboration of State Bar of Selangor with the Anzac Associates. So today our topic is fraud and misrepresentation as grounds of rescission. And I am Nurul Hikmah binti Muhammad Ghazali as your moderator today. And with me there are three panelists. So before we start with the first panel, I will brief to all of you what is the rescission actually. Rescission is an equitable remedy which allows a contractual party to cancel the contract. Thus, victims of arbitrating factors such as misrepresentation, fraud, mistake, dress, or undue influence may apply this remedy. And what is the purpose of rescission is to restore the status quo ante, which means the state of affairs existing before the contract was entered into. As an example, when a contract transferring title to property is rescinded, it usually has the effect of revesting any property so transferred in the transferor. And the next, I also want to add the case of Johnson and Agnew, where in this case, the plaintiff was not allowed to apply rescission as the repudiatory breach that occurred in this agreement does not bring about rescission ab initio. And then for the next session, for the next explanation, I would like to invite the first panel, which is Miss Nurin, to explain more about the fraud.
Assalamualaikum warahmatullahi wabarakatuh and a very good morning to our honorable guests and audience. Before I begin, I would like to thank our moderator, Ms. Hikmah, for inviting us today. My name is Nurin Shakira binti Muhammad Azli. It is an honor to be given the opportunity to share with all of you today the topic of fraud as ground of rescission. So first of all, we will first look at the definition of fraud. Fraud has been defined in Section 17 of Contracts Act 1950, which it states that certain acts that are committed with intent to deceive another party or to induce him to enter into the contract. So according to this provision, there are some key points need to be highlighted here, which is the maker of statement does not believe in his own statement with intent to deceive another party, and this act will finally result in inducement of a contract to be entered by the other party. So under Section 17, there are 5 different acts of the defrauder that may constitute fraud. So I will explain this point briefly in the next slide. Okay, the first act that may constitute fraud is representation of untrue facts. So basically, the requirements under fraud is similar to misrepresentations, whereby there must be a false representations of fact addressed to the misled party. However, the only difference is in terms of state of mind of the maker of statement, in which under fraud, the maker himself does not believe that the statement made by him is true. So for instance, we may refer to illustration A of Section 19 of Contracts Act 1950, which illustrates A intending to deceive B had falsely represented that 500 gantangs of indigo are made annually at A's factory and thereby induces B to buy the factory. So therefore here the contract is voidable at the option of B. So secondly, there is a fraud in situation where a party actively conceals or prevents certain material information from reaching to the other party. To be more specific, we may have a look at illustration C of Section 19 of Contracts Act 1950, which it states that B, having discovered a vein of ore on the estate of A, adopts means to conceal and thus conceals the existence of the ore from A. So through A ignorance, B is unable to buy the estate at an undervalue. So this illustration shows that B took an active steps to conceal the material fact from the other contracting party. So therefore, in order to establish fraud, the defrauder must do something which he may need to take some active steps to hide the existence of the fact from the defrauded party. The next action that may lead to fraud is fraudulent promises, where a promise is made without intention to perform it. So these fraudulent promises can be either in the situation where the promiser knows that he cannot perform the promise when he made it, or in situation when he makes a promise that he intends to break. So other than those acts that I have been mentioned before, fraud may also happen if there is any other act fitted to deceive. So this is actually a catch-all clause to avoid or to prevent any fraud escaping the net of the law. So we refer to the case of Loy Hiang Cheong and Kon Tak Chi, where in this case the appellant was a land broker and he had exchanged his land in Cebu worth only $55,000 for the respondent land in Kuching, which worth $115,000. So in this case, he falsely told the respondent that there had been an offer of $175,000 of his land, although the respondent in this case actually did not believe on the appellant's valuation of the Cebu land, but still the appellant managed to convince both land had the same value. So since there was unfair and unreasonable exchange of land, the court decides that there was a fraud involved in this case. Last but not least, under Section 17, Clause E of the Act, it states that if there is any other law had declared certain acts or omission as fraudulent, then it shall be rendered as fraud. So to conclude, we actually must refer to these 5 acts stated under Section 17 of Contracts Act to establish fraud as ground of rescission. So I hope this will enlighten you more in regards of this topic. That's all from me. Thank you.
Thank you to Miss Noreen. And the next is I would like to invite Mr. Daniel bin Muhammad Daud to explain more about misrepresentation.
Thank you, Miss Hikmah. Hello and good morning to all the chambering students here today. I am Mr. Daniel and I'm going to continue the talk by explaining about misrepresentation in contracts. Okay, a misrepresentation is a false statement of existing or past fact made by one party to the contract directed to the other party before or at the time of the contract's formation, and the maker of the statement believes what he stated is true. As you law students know, offense of misrepresentation is provided under Section 18 of the Contracts Act 1950. As you can see on the slide, it is quite lengthy, right? But as a counsel, I'm going to simplify it for you so you can have an easier understanding about misrepresentation. I have divided it into 4 factors that is needed to establish misrepresentation in a contract, which firstly, there must be the first factor is false representation. There must be some positive assertion made by the representer, and such representation must be false. It must be clear and not ambiguous, and it may be made expressly in writing or oral statement or by some conduct from which a statement can be implied. Next factor is the representation must be one of fact, which means that the false representation made by the representer must be a statement of fact and not a mere opinion. It can be illustrated in the case of Bissett against Wilkinson. The respondent agreed to buy from the appellant a land for sheep farming, and the respondent relied on the appellant's statement that he estimated that the land would carry 2,000 sheep. However, the land in fact could carry less than that said amount. The respondent alleged misrepresentation. However, the Privy Council held that the statement was merely an honest opinion by the appellant and the sale cannot be set aside for misrepresentation. Next factor is the maker addressed the statement to the misled party, which means is the maker or the representer must address it to the misled party. In the case of Pick against Gurney, appellant purchased shares on the faith of false statement contained in a prospectus issued by the promoters of a company. The appellant was not one of the people who received shares when the company was formed because he just bought shares from such allottees. This House of Lords held that the prospectus was only addressed to the first appellants for shares and not extended to the appellant. Thus, the appellant's action against the promoters failed since the false statement in the prospectus was not addressed to him. Next factor is the maker believes in the truth of the statement made, which means is the representer believes that his statement is true and has no intention of deceiving the misled party, although the statement turns out to be false. Therefore, as a legal counsel, we are required to be aware of these four factors in order to establish misrepresentation. That's all from me. Thank you. Back to you, Miss Hikmah.
Thank you to Mr. Daniel. So the last session is I would like to invite our last panel, which is Ms. Nurzana Qadria, to explain the differentiate of fraud and misrepresentation and what is the effect of both of those things.
Hello and good morning everyone, and thank you for having me today. So first of all, I understand that when you start learning about this topic, you will find that differentiating between fraud and misrepresentation is not easy. So here, I would like to explain to you guys the simplest way to determine between these two. Okay, firstly, we can determine it based on a state of mind. In fraud, the statement maker does not believe in the truth of his statement, while in misrepresentation, the statement maker believes the statement that he gives is true and then leads the other party to believe the same thing as he thinks. And one more way to differ between fraud and misrepresentation is the intention, where in fraud, it is done with intention to deceive the other party, but in misrepresentation, it is done without intention to deceive the other party. Okay, so next, what is the effect of misrepresentation and fraud? So the concept of the contract by fraud and misrepresentation, it is construed to be valid between parties unless it is set aside by the misled party, as has been stated in Section 19 Clause 1 of Contract Act 1950. This means the misled party can choose to firm the contract by performing the agreement according to its term and may make a claim of compensation for any loss that had been caused. The second alternative is to rescind the contract. So, together with the choice to rescind, Section 65 of Contract Act 1950 is applied, where the default party need not perform his promise, and if he has received any benefit from the defaulting party, he needs to restore such benefit to him and return to the position as if the contract had never existed. And in addition, a party to a contract who allege misrepresentation of fraud must rescind the whole contract and not only part of it. Okay, that's all for my sharing today. Thank you. Back to you, Ms. Sigma.
Thank you to Ms. Nurzana Qadria for the very good explanation. So that's all for today, and I am very glad to have all of the panelists for this great sharing session. And thank you. See you in the next session.